The International Criminal Court is now in session.
So, good morning, everyone. This is the first session of the last 16 of the Nuremberg Moot Court. Now, I would like to introduce the bench first. My colleagues, Judge Struyven and Judge Owiso, and my name is Kazushige Doi. And at first, I would like to ask you, the prosecutor, for the appearance. After that, ask the defense counsel for appearance. So first, could you introduce yourself, the prosecutor?
Good morning, Your Honor. I am Elizabeth Cole. I will be the first speaker for the prosecution. Mr. Nguyen will be the second speaker for the prosecution.
Thank you.
And Ms. Singanathan will be our third speaker.
Thank you very much. And defense counsel, please.
Thank you. Good day, Mr. President, Your Honors, and my fellow counsels. Pleading on behalf of the defense counsel, my name is Nadina Hayrizani, who shall speak for 10 minutes, together with my co-counsels, Ms. Stephanie Susanto, who shall speak for 8 minutes, and Ms. Calvinka Parawinata, who shall speak for 7 minutes, respectively. We will also reserve 5 minutes for rebuttals. Thank you.
So thank you very much. Then the prosecutor, you have first 25 minutes for presenting your submissions. Please start with your submissions.
May it please the court, my name is Ms. Elizabeth Cole, and I appear before you on behalf of the prosecution. I will be speaking on jurisdiction. Mr. Nguyen will address the issue of admissibility, and Ms. Singanathan will address the remaining 2 issues. Your Honors, over the last 5 years, the Earth Power community have seen their homes raided, their priests arrested and detained, and their religious identity oppressed by the Fire Republic. Years of mistreatment culminate in the case before this court today, involving the unlawful detainment and exploitation of over 30,000 Earth Powers. The prosecution urges that such an egregious violation of human rights should not and must not escape the eyes of the law. At this juncture, the prosecution will prove that there are reasonable grounds for the case to proceed. In doing so, we make 4 submissions. First, this court has jurisdiction as the crime of enslavement is satisfied. Second, that this case is admissible as Lord Blaze's amnesty cannot be invoked to bar trial by the ICC under Article 17(1)(c). Third, that this case is not against the interest of justice. And fourth, that there are reasonable grounds to believe that Lord Blaze is criminally responsible. Moving on to my submissions, this court has jurisdiction as there are reasonable grounds to believe that the crime of enslavement is made out. As furnished in our written submissions, the contextual elements of a crime against humanity are well satisfied. The prosecution instead wishes to focus on the most contentious element today, the specific element of enslavement under Article 7(1)(c) of the Elements of Crime. We submit that the specific element of enslavement is satisfied as the powers of ownership were exercised over the detainees at Centereg. According to the 2003 ICTY case of Konowulak, enslavement is established where the powers of ownership are exercised to such an extent that the individual is deprived of all free will. We know that the defense may contend that there are many lawful instances where an individual can be deprived of free will, such as in the case of lawful detention or imprisonment. However, such lawful detention is an exception to the rule. The individual must be, firstly, confined and made to labor pursuant to domestic laws, and secondly, ensured basic conditions under international human rights law. The present case is clearly not one of lawful detention. The prolonged detention of Earth Powers clearly exceeded the exigencies of the Anti-Extremism Executive Order, and the Fire Republic further contravened international laws regarding security detention when the continued confinement of earth hours was at no point subject to judicial control nor the prospect of trial. Now moving on to the conditions within the detention centers themselves. The earth hours were held in circumstances so coercive as to deprive them of free will, thus amounting to enslavement. The prosecution will prove this and rely on three material facts. First, the earth hours were subject to a regime of forced labor in inhumane conditions. Not only were they forced to build and repair cars for 12 hours a day, every day of the week, they were given barely a period of rest in between. Where they refused to work or were too weak to do so, they would be forced to stand in the snow in front of a picture of Lord Blaze, starved of food and water for an entire day. Second fact, the Fire Republic's control extended to their exercise of culture and religion. Not only were they barred from practicing their religion, but they were banned from speaking the vernacular language. This is quite clearly a violation of their fundamental human dignity, as well as their right to pursue social and cultural development. Lastly, the deprivation of freedom of movement on Centerrig is clear. Much as in the case of the 2001 ICTY case of Cunard, the victims were held to be enslaved as they could not escape their sexual abuser's place of residence. In this case, Centerrig was a heavily guarded facility on an isolated island, and the detainees had their passports confiscated upon arrival. It is quite clear that in such circumstances, the liberty of movement and choice was evidently denied. Your Honours, in such coercive circumstances, it is plain to see that the earth hours were denied all free will. From the moment they were unlawfully arrested and detained, they were stripped of their cultural identity, forced to labor in circumstances that were overtly coercive, and most fundamentally, robbed of their human dignity. The prosecution submits that this court has jurisdiction as there are reasonable grounds to believe that the crime of enslavement has been satisfied. If I may be of no further assistance to this court, I now pass my time on to Mr. Nguyen, who will address this court on the issue of admissibility. Thank you.
Before you call it a day, just one question. The charge here concerns crimes against humanity, and the conflict in Black Mound, to my understanding, involved AANG combatants. So, to what extent does the population in Black Mound still qualify as a civilian population within the meaning of Article 7 of the Rome Statute?
Your Honour, we submit that they are still a civilian population. According to the 2019 ICC case of Antaganda, even where there are military combatants present within the population, it would not make sense to deny them of their civilian status because of the presence of, in this case, Anglo-Royalists. The earth hours were primarily civilians, and those who were brought to the detention centers had not committed any acts of terror or crimes. So we submit that they are still a civilian population in this case.
Thank you.
So if I may be of no further assistance, I conclude my submissions. Thank you.
May it please the court, my name is Nguyen Minh Tri, and I represent the Office of the Prosecutor. What is before you today, Your Honour, is an accused person who preemptively sought amnesty to trigger nebis in idem, to escape domestic and international prosecution. To this, the prosecution says that the case must be admissible for either one of two reasons. First, Lord Blaze has not been tried by another court within the meaning of Article 17(1)(c). Second, because law number 14 infringes upon Fire Republic's obligations to prosecute and punish perpetrators of crimes against humanity to the extent that Lord Blaze relies on it to bar prosecution by this court for enslavement. Your Honours, Article 17(1)(c) states that a trial by this court is not permitted if an accused person has already been tried by another court Your Honors, what it means to be tried certainly is more than just about there being a judgment. There needs to be three elements that needs to be satisfied in order for this court to find that an accused person has already been tried. First, there needs to be an indictment. This is a formal identification of the conduct alleged to be the crime. Second, there needs to be a decision on the merits of those charges. Now, what this means is that there needs to be an examination of whether the accused conduct amounts to a crime by the domestic court. Third, even if we accept that there is no examination on the merits of those charges, say in cases where the accused pleads guilty, there still needs to be a final conviction or acquittal. These three elements are found in both cases from the ICC and ad hoc tribunals interpreting Nebis in idem. The case in Benba, Gaddafi in this court are illustrative, and as for the ad hoc tribunals, Semenza case in the ICTR and Tadic. Your Honours, in the present case, it is beyond dispute that there are no formal proceedings other than a confirmation by the judge. Without being indicted, nor subject to a decision on the merits, there simply could not be an acquittal or conviction. And it does not lie in the mouth of Lord Blaise to say that he has been tried by another court. Now, what is more crucial and lacking in this case is the examination of Lord Blaise's criminal responsibility. All the Fire Republic judge did here was to simply assess whether the procedural requirements of law number 14 are made up. Now, this might be analogous to the ICTR case of Semenza, where a previous decision that only examined the admissibility of an extradition request by the Rwandan government was not considered a decision on the merits, and therefore Nebis in idem was inapplicable. The same argument applies here. And Your Honours, perhaps what is most disconcerting is how Lord Blaise, at paragraph 23 of the facts, only sought amnesty to protect himself against potential criminal prosecution. Now, this is especially telling because it is nothing more than an indication that there were barely any criminal proceedings at Fire Republic, let alone a trial. Being subject to an administrative amnesty judgment that has nothing to do with Lord Blaise's criminal responsibility will not, cannot, and has not caused prejudice to Lord Blaise should a trial by this court be allowed. Article 17(1)(c) is not made out, and this case remains admissible. And in the alternative, this court should still attribute no weight to law number 14 to the extent that it blocks prosecution by this court for the crime of a crime against humanity of enslavement. Because doing that would allow Fire Republic to evade its obligations under the Rome Statute, effectively shielding Lord Blaise from criminal responsibility. As far as the ICC and the Rome Statute is concerned, there exists an obligation on the part of state parties to investigate, prosecute, and punish perpetrators of crimes within the jurisdiction of this court. This is also affirmed in recent ICC jurisprudence in a separate judgment of the appeals chamber in Gaddafi in 2020, and the El Bashir judgment. Your Honours, having ratified the Rome Statute in 2004, the Fire Republic is obligated under the Rome Statute to investigate, prosecute, and punish perpetrators of enslavement. Now, what that means before this court today is that amnesty proceedings cannot be invoked because that would go against the very object and purpose of the Rome Statute. As rightly noted by the International Military Tribunal at Nuremberg, individuals have international duties which transcend the national obligation imposed by the individual state. Your Honours, the prosecution has shown why this case is admissible and that a state cannot unilaterally cast into oblivion an international crime when such a crime would not be forgotten by the international community and the very victims of the crimes itself. And if your honors have no questions, I will conclude my submissions. I'll pass my time to Ms. Singanathan, who will now address the issues of interest of justice and superior responsibility.
Your Honours, may it please the court. My co-counsel, Ms. Koh, earlier showed that there are reasonable grounds to believe that the Earth Bowers in Fire Republic were enslaved by the Fire Republic officials. The prosecution has identified Lord Blaze, the head of the state of Fire Republic, as the person most responsible for these crimes. We have two further reasons why this case must proceed. First, there are no substantial reasons why the case is against the interest of justice. And secondly, there are reasonable grounds to believe that Lord Blaze is criminally responsible as a superior for the crimes against humanity of enslavement committed. The prosecution submits that there are no considerations of the interest of justice which should bar this court from proceeding. This is firstly because this court has no power to review the interest of justice factor in this case. Article 53(1)(c) and 53(2)(c) of the Rome Statute reserve this factor entirely to the prosecution. As noted by the Appeals Chamber in the 2020 ICC decision of authorization of investigation in Afghanistan at paragraph 29, the court may only review the interest of justice factor where the prosecutor has decided not to proceed with the case. And the reason for this is that review is meant to protect against impunity. In our case, however, given that the prosecutor has already decided to proceed, this basis for review does not exist. In any event, we submit that the defense's challenge is not supported on the facts. There are no substantial reasons why proceeding with the case would be against the interest of justice. The potential destabilizing effect of the peace process raised by the defense is only relevant to us to the extent that it involves crime prevention concerns or security concerns. And this was explained in the 2007 OTP policy paper on interest of justice at page 9. There is no evidence in our case that the case against Lord Blaze has caused more core crimes to be committed or has threatened the safety and well-being of victims and witnesses. Furthermore, the OTP is able to take a tailored prosecutorial approach that will allow it to manage any potential security concerns that may arise. In Uganda, for example, the prosecutor adopted a low public profile and refrained from making any public statements that would interfere with the local peace process. We can do the same thing in our situation. Hence, the defense's challenge on this ground must fail. In fact, Your Honours, there are compelling policy reasons why this court should allow the case to proceed, because it is required to meet the interests of victims. Contrary to the defense's assertion, it is not ICC prosecution which will destabilize the peace process, but Fire Republic's own failure to meet the interests of its victims. Both the TRC report published and the public apologies made by the amnesty applicants fail to meet victims' right to the truth. Clarification 5 of the facts shows that all that the TRC report states is that both parties to the conflict committed crimes. It fails to state facts like how and why the crimes were committed. It fails to identify those responsible for crimes, and it does not declare the criminal responsibility of those involved. These are all criteria identified by the ICC PTC in the 2008 Decision on Victims' Procedural Rights in Katanga at paragraph 32. As for the public apologies, the case facts at paragraph 20 show that Fire Republic has failed to put in place any safeguard that can ensure the truthfulness of these apologies. State practice in countries such as Chile and South Africa has shown that a credible threat of criminal prosecution in the absence of truthfulness is needed to incentivize truthful apologies. However, in the present case, there was no requirement for the Fire Republic judge to be satisfied of the truthfulness of Lord Blaze's public apology before he granted the amnesty. Hence, the peace process measures in Fire Republic fail to provide the victims with the truth. Furthermore, despite Fire Republic's purported claims that it has promoted peace and reconciliation, we are aware that since the release of detainees, many of them have fled from Fire Republic to Water Kingdom. Therefore, this court should not dismiss the case on the basis of interest of justice, because it is needed to prevent impunity as well as to meet the interests of victims. Moving on to my final submission, we will show that there are reasonable grounds to believe that Lord Blaze is criminally responsible for crimes against humanity of enslavement under Article 28B of the Rome Statute. We have three cumulative arguments. First, that Lord Blaze had the requisite mens rea. Second, he had effective control and responsibility. And third, he failed to take necessary and reasonable measures. As a preliminary point, at this stage of the proceedings, the court only has to be satisfied that there are reasonable grounds to believe that Lord Blaze is responsible. This is pursuant to the ICC Appeals Chamber in the 2010 Al-Bashir decision on warrant of arrest at paragraph 33. This means that the court only has to be satisfied that Lord Blaze's responsibility is one reasonable conclusion on the evidence. It does not need to be satisfied that it is the only reasonable conclusion. We submit firstly that Lord Blaze had the requisite mens rea under Article 28B, subparagraph 1. Taking the evidence as a whole, there are reasonable grounds to believe that he possessed information referring to the enslavement by his subordinates, yet he consciously disregarded it. The evidence shows that firstly, Lord Blaze had knowledge of the history of violence and religious oppression being committed by the Fire Republic officials against the Earth Powers. Yet, in this context, he chose to give his subordinates broad powers to use any necessary means against them. Secondly, he had a high degree of control and involvement in Center-Rig, such that he must have possessed information on the enslavement, either through reports or other means. We know that Center-Rig was created pursuant to his anti-extremism order, and again decommissioned at his will. We see from the communications in Exhibit 1 that he had the power to directly question Ursa Azila on the situation in Center-Rig. He was able to give her direct orders to send detainees from Center-Rig to Center Lotus, and he had the authority to make logistical arrangements to allow Center-Rig to operate. And thirdly, we see that the crimes were so notorious that it is disingenuous for Lord Blaze to claim that he did not have information on the enslavement. This is especially so because even members of the public and people outside of Fire Republic had awareness of the human rights violations. Joe Snowflake, someone in Water Kingdom, wrote a letter distancing his company from the Fire Republic detention centers, and he also condemned Fire Republic's treatment of Earth Powers. We also know that an anonymous person took aerial footage of Center-Rig and submitted it to JHR. Looking at all these circumstances cumulatively, it is simply not believable for Lord Blaze to say that he did not at least have information which indicated the crimes. Therefore, there are reasonable grounds to believe that he had information which clearly indicated the enslavement and that he consciously disregarded it. The very same reasons also go to show that he had effective control and responsibility over the activities in the detention centers and could have repressed the crimes if he had restrained his subordinates. This brings me to our third argument, which is that in spite of his control and his possession of knowledge, he failed to take necessary and reasonable measures to prevent the commission of the crimes, such as by reporting the matter to the fire police for investigation. Hence, there are reasonable grounds to believe that Lord Blaze is responsible as a superior under Article 28B for the enslavement committed. Your Honours, the Earth Powers in this case were deprived of their liberty, their dignity, and their humanity. We urge that this court allow the case to proceed in order to prevent impunity as well as to give justice to the victims. If I may be of no further assistance to this court, this concludes my submissions.
So thank you very much. Then, Defense Counsel, could you present your submissions now, please?
Thank you, Mr. President. Good day, Mr. President, Your Honors. My name is Nadina Hayarizani, and I shall be addressing the claim on jurisdiction, whilst my co-counsel shall deliver the submissions on admissibility, the interest of justice, and Mr. Blaze's responsibility under Article 28B of the Rome Statute. Mr. President, Your Honors, in 2018, the Fire Republic had suffered a violent attack from the Association for an Autonomous National Government, a separatist movement with terrorist leaders striving to divide the country. Mr. Blaze, as a responsible president and a man who had sworn to protect his country, had taken decisive acts to suppress these violent clashes, and he had also set out to rehabilitate the terrorists through education and skill building. And with this, Your Honors, his effort of eradicating a dangerous act of terrorism shall not be mistaken as the most serious crimes of international concern. Your Honors, the Defense Counsel will firstly establish on how the court does not have jurisdiction in the present case, as a crime against humanity of enslavement had never occurred in the first place. If there are no preliminary inquiries, I shall move on to my submission. May it please the court. Your Honors, in today's proceeding, the Defense Counsel will focus on establishing that the subject matter jurisdiction is unfounded. We would like to respond to the prosecution's submission, where the defense contends that the specific elements of crime against humanity of enslavement is unfulfilled in the present case, by contending two grounds. That first, there has not been any exercise of ownership towards the persons, and second, there has been no exaction of forced labor. In assessing the first point, Your Honors, pursuant to Article 7(1)(c) of the element of crimes, an exercise of ownership is seen through, among others, the deprivation of liberty. The prosecution has disputed that the deprivation of liberty is imposed through how the persons were being arrested and detained. However, Your Honors, in any case, if we may direct the court to the case of Kaing of the ECCC, the court has found that there is no enslavement where the control has an objective other than enabling the exercise of the powers attaching to the right of ownership. And this is what happens in the present case, as the objective of arresting these persons were not for exercising ownership towards them. Rather, it was a necessary measure to suppress the violent clashes and to further rehabilitate the terrorists. And thus, it cannot be said that this was an act of exercising ownership towards the persons in center right. And consequently, we would also like to address our second ground of the specific elements, that we contend that there has been no exaction of forced labor. Your Honors, forced labor can be manifested through, first, the involuntary labor, and second, the uncompensated work. However, we submit that, firstly, the prosecution has failed to establish that the persons were imposed to involuntary labor. This element is seen when the persons do not have any choice but to fulfill a certain work. In the present case, this is not evident, as before being put into the educational facility, the detainees were given a choice as to whether they want to participate in the educational programs or not. And thus, it cannot be said that this was of an involuntary nature. And secondly, Your Honors, the persons' work were indeed compensated by the reduction of their sentence by 2 months. And furthermore, this form of compensation is accepted based on the court's decision in the case of Floroiu versus Romania of the ECTHR. And thus, it will be improbable to conclude that these persons' work were uncompensated. And lastly, Your Honors, we would like to address that the allegations of maltreatment is unfounded. If we may remind the court, these allegations of maltreatment was only obtained from one witness's testimony, which is Haru Rock, a leader of the AANG who has positioned themselves against the government. Any statements made by Haru Rock might be of a biased nature. And furthermore, it was concluded in the case of Karnataka that evidence of a conclusion drawn by witnesses without more does not establish the element of forced labor. And thus, considering that Haru Rock's statement is indeed unsupported by neither other testimonies nor corroboration of evidence, the court shall take careful decisions on applying the statement to the current case. And with this, Mr. President, Your Honors, we conclude that since neither of these elements are satisfied, it shall be established that there are reasonable grounds to believe that a crime against humanity of enslavement is unfounded in the present case. And with this, the Defense Counsel would like to continue our submission, and I will give the floor to my co-counsel, who shall challenge the admissibility and the interest of justice. Thank you, and may it please the court.
Thank you. Good day, Mr. President, Your Honors. My name is Stephanie Susanto, and I will be speaking to submit the challenge on the admissibility and the interest of justice. May it please the court. Mr. President, Your Honors, whilst in the past, amnesties may have been seen as an unjustifiable recourse for justice, recent developments have shown that if conducted as part of an effort for transitions from violence and through the proper procedures, amnesties given must be respected by the international community. Even the deputy prosecutor of the ICC in the preliminary examinations of the Colombia case referred to the application of the principle of complementarity in situations involving transitional justice measures, and the Secretary General of the UN, Kofi Annan, argued that the ICC should not intervene in the case of South Africa in light of the effort from the national government for restorative justice. Mr. President, Your Honors, the South African model has shown the international community and the International Criminal Court that amnesties are not a tool to simply forget wrongdoings, but are a means of change to restore peace. In the present case, the Fire Republic's Amnesty Law and Truth and Reconciliation Commission was given and drafted as part of its transition to a more peaceful situation, and has ensured that the amnesty aligns with principles of international law. Firstly, it has received legal validation by the national authorities. It provides the conditions to preserve peace in the country, such as by providing disarmament and public apology, and also provides judicial control, where persons who are not eligible or does not fulfill the conditions will be subjected to ordinary investigation and prosecution. Mr. President, Your Honors, accordingly, the defense invokes Article 17, Paragraph 1c of the Rome Statute and submits that Mr. Blaze has been tried by the amnesty trial, which has resulted in a final judgment, and therefore the case shall be inadmissible before this court. We would like to respond to the prosecution submission on 3 points. Firstly, the prosecution has argued that a trial falls short of the definition of a trial in Article 17, Paragraph 1c. However, we submit that in the Gaddafi admissibility decision, the main consideration for the chamber was whether something that can recognizably be described as a trial has occurred. A trial can then be defined as a formal judicial examination and determination in a proceeding, where in this case, there was an examination carried out by the judge and a determination of whether the amnesties may be granted, and hence the proceeding can be categorized as something recognizably described as a trial. Secondly, the Gaddafi case did not delve into discussion of the necessity of a decision on the merits that needs to be present, and what needs to happen is that the decision has reached the finality of a res judicata effect, by which it is no further subjected to appeals. And this is present in the current case, as pursuant to clarifications, paragraph 6, Mr. Blaze's trial has reached a res judicata effect. Secondly, we also submit that the prosecution has misconstrued Mr. Blaze's statement provided in case facts paragraph 23. As first, we emphasize that Mr. Blaze's personal intention bears no weight under the discussion of the assessment of complementarity, and secondly, that the decision of the trial was taken after thorough assessment from the impartial judge, and hence it must not be misconstrued as an act of shielding. Thirdly, we submit that we agree with the prosecution that the state has a duty to investigate and provide effective remedies which shall entail the effective search for truth. However, in the present case, in accordance with case clarifications paragraph 5 and pertaining to the conditions within the FIRE Republic which aims to provide national reconciliation and stability, the Truth Reconciliation Commission has facilitated this duty and even published their reports on the matter, and therefore the duty to investigate has been fulfilled. Lastly, we'd like to assert that the definition of impunity would refer to the impossibility of the defendant being investigated, charged, and prosecuted. The fact that we are here before the chamber today is already a living proof that we are not against impunity. If by any case the defendant would be free due to a sufficient legal justification, that is not impunity, it is merely a decision of a proceeding where it happens to be in favor of the defense. Therefore, Mr. President, Your Honors, contrary to what the prosecution has submitted, in light of reasonable and genuine national efforts for justice, accepting Mr. Blaze's trial on the national level is not equivalent to simply disregarding alleged crimes, but that indeed the court has a complementary nature and that the FIRE Republic has undertook the most reasonable recourse any country would take in restoring peace and protecting its citizens. Mr. President, yes, Your Honor.
Just clarify one thing for me here. In this particular case, the prosecutor has determined that they are proceeding with investigation. In this case, therefore, does this chamber have the authority to assess the interest of justice criteria?
Thank you, Your Honor. That is exactly what I am going to submit on my third submission on the interest of justice, is that this chamber must conduct judicial scrutiny in order to assess the soundness of the prosecutor's submission or conclusion over the Article 53 interest of justice assessment. Your Honor, we do understand the prosecution's submission that the court has no statutory power to review the interest of justice. However, the chamber must be able to assess the soundness of the prosecutor's conclusion, and there seems to be enough support to the view that the pretrial chamber is indeed entitled and actually required to review the prosecutor's decision that an investigation or a prosecution is in the interest of justice, such as within the Burundi and Georgia situations, where the court clearly said that the chamber is required to assess. Even Judge Karenza, in its separate opinion of the Afghanistan decision, decided that the principles of transparency and accountability of international rules of law requires that any decision, be it from the prosecutor or first instance chamber, must be subjected to judicial review. And this is why we submit that the pretrial chamber does indeed have the power and is required to conduct judicial scrutiny over the interest of justice assessment. Secondly, even as the prosecution has submitted that there is no reasons that the prosecution of Mr. Blaze would not be in the interest of justice, we submit that there are several circumstances that had been overlooked by the prosecutor, which the chamber must assess in order to clearly determine whether a prosecution of Mr. Blaze will impact the peace and the interest of the victims in the current case. Firstly, we submit that it is not in the interest of justice to prosecute if the national peace and stability of a state will be distressed. Looking back at the Uganda situation, which has also been invoked by the prosecutor, the ICC proceeding towards the LRA had created detrimental impacts as the country descended back into conflict and violence. And in the current case, we have seen that the AANG organization is constantly searching for opportunities to attack the Far Republic, as illustrated in paragraph 17 of the case facts. We simply cannot risk the lives of many in comparison to the prosecution of a single person. We also have to consider the weight of Mr. Blaze's influence and the fact that peace is not yet established. With prosecuting Mr. Blaze, the prosecution would risk the country falling into political turmoil, which will certainly worsen the situation at hand. The risk that the ICC would be taking for the prosecution of a single person who may not even be responsible for a crime yet to be established is simply too great. Secondly, Mr. President, Your Honors, we submit that there is a lack of participation and interest by the victims, as until this date, contrary to past cases where the alleged victims actively spoke out and demanded for prosecution, there is no such demand in Mr. Blaze's situation. Even in the early stages of preliminary examinations and investigations, in the Afghanistan and Georgia cases, the prosecutor was able to provide that there are several victims, alleged victims, who were keen to see and demanded for prosecution. But in this case, there is no such demand. If a prosecution were to continue, then how can the court assess without the participation of the victims? And this is why the element of the victim's interest is considered as detrimental within a case, and why we submit that in light of the insufficiency of this element, a prosecution would simply not be in the interest of justice. Lastly, the interest of justice is better served through the already established mechanism of redress through the Truth and Reconciliation Commission, which will balance justice with the need for national reconciliation and peace building. Mr. President, Your Honors, we submit that the court must evolve alongside with the developments within the international community and must not allow legal boundaries to prevent the court from taking the correct choice in developing practice of judicial supervision in discretionary choices in order to safeguard the credibility of this court. It would be unfortunate for the existence and operation of the ICC to stand in the way of peace agreements and national transitional justice initiative. Mr. President, Your Honors, with that being said, I'll reaffirm on the defense's submission that the case against Mr. Blaze is indeed inadmissible and not within the interest of justice. And I will give the floor to my co-counsel, Ms. Porawinata, to continue with the submissions. Thank you, and may it please the court.
Excuse me, counsel. I do have a question about your reference to the Uganda case and how a possible prosecution would have disturbed the peace process. Do you know factually what happened after the arrest warrants were issued in the Uganda case and how it disturbed the peace process, in your opinion?
Certainly, Your Honor. First of all, the arrest warrants, which were issued against the leaders of the LRA, Joseph Kony, Vincent Oti, Okot Odhiambo, Dominic Okwen, and Raska Lukuya, closed down incentives for them and the High Command to engage confidently with the peace processes and cause an impasse within the peace processes. And this did not resume in many years, which had resulted in detrimental impacts within the situation of the country, both politically and towards the victims or the citizens of the Uganda case. And in this case, we submit that a politically unstable situation, especially where the AANG organization is lurking around the corner for opportunities to attack the Far Republic, is simply too great of a risk for this chamber to take in this present case. And Madam President, if I may not be further assistance, I will give the platform to my co-counsel. Thank you very much.
Good day, Mr. President, Your Honor. My name is Kelvinka Porawinata, and in virtue of continuing the defense's submission, we contend that Mr. Blaze cannot be criminally responsible for the crimes against humanity of enslavement under Article 28B of the Rome Statute. And if there are no preliminary inquiries, we will continue with our submission. Thank you, and may it please the court. Your Honors, in light of the jurisprudence and the history of international criminal law, we must consider as well the international military tribunals and the Nuremberg trials. We see that there has been either a void of or conflicting assessments regarding the elements of a civilian superior's effective control. Thus, we cannot possibly argue that Mr. Blaise, as the President of the Fire Republic, has no authority whatsoever. In fact, as the defense does not contest that Mr. Blaise has authority, we only attest that the authority he yields is in his simple exercise of power as President, of which Your Honors does not fulfill the restricted boundary of a non-military superior in its doctrine that the Bagalashema Appeals Chamber finds to solely cover military-style situations. In supporting this, we submit that in reference to the Cordic and Cherkes trial chamber, although the accused's formal position is indeed the starting point of assessing criminal liability, the actual authority cannot just be determined by merely that. In fact, Your Honors, whether de jure or de facto, military or civilian, the existence of a position of authority will need to be based on the assessment of the reality of the accused's authority. In this, Your Honors, we urge the court to focus on what three criteria have already been stipulated under Article 28B, that is the duty to prevent, to repress, and to submit. This is to assess whether Mr. Blaise is indeed of the highest responsibility over the alleged crimes against humanity of enslavement. Your Honors, in the judgment of Kazushige, the actus reus to show criminal responsibility is in the consideration of these three factors. We submit that this has been done so by Mr. Blaise. First of all, Mr. Blaise did not know and did not disregard any information indicating that the alleged conducts were being committed or about to be committed. Your Honors, one of the reasons why there has been much higher thresholds placed upon non-military superiors is because superiors in civilian structures generally do not have as many possibilities to receive information on the conduct of their subordinates as do military commanders. In this case, because knowledge in Article 30, subparagraph 3 entails an awareness that a circumstance exists or that a consequence will occur in the ordinary course of events, actual knowledge of a superior cannot be presumed. Your Honors, as can be seen in the judgment of Bemba and mirrored in the Oric trial judgment, the superior is needed to know what the subordinates are doing in these situations. Your Honors, this is required to see if the perpetrator knew. Fortunately, Your Honors, the knowledge of a superior can be proven by several factors, such as an established reporting and monitoring system. Yet, Your Honors, in response to prosecution, how can the preventive mechanisms by Mr. Blaise show that he has the mens rea if, Your Honors, respectfully, the information available to Mr. Blaise did not speak to any alleged conduct? In fact, pertaining to Exhibit 2 and Exhibit 1, we see that Mr. Blaise has asked for more information, but no information was given to him. And in this, to clinch the point, we see that there has also been disturbances in Exhibit 1. There are reasonable grounds to believe, Your Honors, that Mr. Blaise was unwillingly kept in the dark and was no way Mr. Blaise unconsciously or consciously disregarding any information. If anything, Your Honors, Mr. Blaise has done his due diligence. He has taken all the necessary and reasonable measures within his power. In the judgment of ICTR Nidilinimana, the Chamber notes that international law does not provide a detailed list of preventive mechanisms or modes of punishment that a superior is bound to adopt in order to fulfill his duties. The law only requires that a superior adopt measures that are necessary and reasonable in order to prevent or punish crimes committed by his subordinates. In this case, a determination of what constitutes as necessary or reasonable is in a specificity of the case and must see the circumstance of the case. Your Honors, because of this, we contend that Mr. Blaise has set in place the most appropriate measures of action upon the alleged conducts being revealed. In fact, Your Honors, in the light of the truth revealing itself, Mr. Blaise acted promptly. He sought out a Truth Reconciliation Commission and also provided recourse of prosecution for those who do not fulfill Law Number 14 on national reconciliation. Your Honors, additionally, following the signing of the peace agreements, Mr. Blaze swiftly closed all the detention centers and released the Earth Hours and the AANG members, of whom I add are terrorists, Your Honors. If this does not show how Mr. Blaze strives to upkeep peace and stability, then we take a look by how, complementing peace processes, he strives to empathize and apologize publicly for the conducts that have occurred. Your Honors, Mr. President, respectfully we submit that Mr. Blaze's actions are to protect the integrity of his republic from terrorism and extremism, which can be seen from paragraph 7, when he issued anti-extremism order. His theme was always secure from the beginning, and these measures were reasonable and necessary, and in no way breach upon set international standards. Therefore, Your Honor, we request this court to adjudge in favor of protecting the entirety of the Fire Republic. If we may not be of further assistance, the defense will conclude our submission here. Thank you, and may it please the court.
So thank you very much. Now, so we give you both for rebuttals for 5 minutes for each side. First, prosecutor, please.
Apologies, Your Honor, I was muted. We have 4 points to make in rebuttal. First, the defense has argued that there was no enslavement because the labor was voluntary. With respect, Your Honors, what is important here is not whether they were given a single choice, but whether the Earth Powers were placed in such coercive conditions as to negate an exercise of free will. As explained in the 2003 ICTY case of Chronoyolek at paragraph 193, the victims there were given a choice between staying in prison dorms and working in mines, but the appeals chamber found that there was still enslavement because the conditions in the prison dorms was so coercive as to deny them of an opportunity to exercise free will. Similarly, in our case, there is an ostensible choice, but we know that from the objective circumstances of detainment and punishment, the Earth Powers were not actually able to exercise any choice. Our second response is in response to the defense's argument that there was a trial because the conditions for the amnesty were fulfilled and the judge made a final decision. However, we say that this is not sufficient to make the proceedings a real trial. It is true that the Gaddafi appeals chamber stated that a final decision is necessary for there to be a trial, but a final decision is not the only thing that is needed for a trial. We can see from paragraph 20 of the case facts that the judge merely conducts a very superficial review of the conditions. He does not look at the criminal responsibility of the individual, but merely looks at the form of whether an apology has been made. Professor Kai Ambos has said that we must distinguish between an amnesty committee with a limited mandate, such that it seeks to protect criminals with impunity, from an amnesty committee with broad mandate that can actually result in criminal justice. In our case, given that there has been no disclosure of truth and no assessment by the judge of criminal responsibility, we say that there is no trial under Article 17(1)(c), and the case is still admissible. Thirdly, the defense has submitted that prosecution is not in the interest of victims because no victim has come forward. Your Honors, this is all the more reason why prosecution is in the interest of victims. It is highly suspicious that given that 30,000 Earth Powers are suspected to have been victims, not a single one of them can be reached for interview to speak about what they underwent in the labor camps. And can we really expect that a Truth and Reconciliation Commission, headed by Fire Republic officials appointed by Lord Blaze, can truly meet the victims' interests in this respect? In any case, Your Honors, given that this court has a duty to prosecute grave crimes, to prevent their impunity and to contribute to the deterrence of those crimes, we owe the prosecution in this case as an obligation to all the other state parties to the Rome Statute, such as Earth Nation, which referred the situation to the ICC. My last point, Your Honor, is in response to the defense's argument that Lord Blaze has been kept in the dark relating to the enslavement. And even though he asked for more information, he failed to receive this information. This is simply not true. We know that he definitely did have more information. Exhibit 1 shows that he did indeed receive a report from Ursa Azila that is not yet available to us. And we know that the Exhibit 1 is a mere excerpt of the telephone conversation between Ursa Azila and Lord Blaze. From line 7, we know that Lord Blaze knew that a mutiny was going to occur, which shows that he had awareness of what was going on in Center Rig. Given these circumstances and given his control, his position as president since 2014, and the fact that external parties had awareness of the human rights violations, this court must conclude that it is at least one reasonable conclusion that Lord Blaze had information on the enslavement. Your Honors, I note that my time has elapsed. If I may assist this court no further, this concludes my rebuttals. Thank you.
So thank you. Then defense counsel, please.
Mr. President, Your Honors, unfortunately, the patchwork of the prosecution's rebuttals are sown with misapplications and misinterpretations of law and fact. We can see this as in the first point of rebuttals, Your Honors, respectfully, there has been no crime against humanity, and the court is not empowered to adjudicate upon the case. Firstly, Your Honors, all of the evidence that the prosecution alleges to be enough, such as number 1, the aerial footage, and number 2, the exhibits, only show that a lawful detention was conducted, where the persons held were given educational programs in order to better help them reintegrate into society. What it does not show is that an act of mistreatment or enslavement has been conducted. Your Honors, secondly, the defense counsel would like to reaffirm that the prosecution's allegations of elements of enslavement was only based on one biased testimony. Your Honors, this testimony was not in any way corroborated by any other testimonies. Therefore, the court shall rather rely on the facts that has been addressed, which concludes that since neither of the elements of exercise of ownership nor forced labor is established, we assert that the court has no jurisdiction to adjudicate upon this case. Mr. President, Your Honors, furthermore, the defense would like to challenge that in the admissibility of this case, we would like to remind the court respectfully that the main reason as to the creation of the admissibility claim is to complement the national jurisdiction. In the present submission, the prosecution has failed to take into account the holistic nature of the situation of the Fire Republic. Your Honors, the defense submits that the situation in the Fire Republic is a distinct one, where there exist national peace processes and alternative justice mechanisms, and we pray that the court is able to respect this. As the prosecution has clearly worded by referring to Prof. Kai Ambos, an amnesty commission can and must be characterized as a trial failing under Article 17(1)(c) of the Rome Statute. Your Honors, respectfully, on the next point of rebuttal, the prosecution has submitted that a possibility that the ICC proceedings will impact the peace processes negatively is simply not enough to establish that a prosecution is not in the interest of justice. Mr. President, Your Honors, we would like to ask the court a simple question. Should we wait for a country's deliberation of peace and chaos to further ensue to stop a mere single prosecution? We submit that the risk is far too grave and great for the ICC to prosecute them. Lastly, the defense submits that the prosecution's allegations that the persons held were silent is unfounded. In paragraph 9 of the facts, it stipulates that the released detainees systematically decline to comment on or even speak about their experience, unquote. Hence, these systematic refusals must not be twisted and misinterpreted as being caused by an act of silencing, but merely that the persons refuse to speak of their experience, and we must respect this. Until the prosecution can provide concrete proof that this is the case, then this argument will fall. Your Honors, last but not the least, in regard to the prosecution's submission on Mr. Blaze's criminal responsibility, again, we would like to assert that Mr. Blaze, as civilian superior, it's not that he did not have authority, Your Honors, but that he did not have effective authority and control. Your Honors, Mr. Blaze, as president, indeed has the power, of course, of authority to communicate with his subordinates, but this cannot simply show that Mr. Blaze was of the highest responsibility. Your Honors, in response to the prosecution that submit that in Exhibit 1, Mr. Blaze has warned of a possible mutiny, we respectfully ask the court, how is a mutiny related to enslavement? And Your Honors, that just shows that Mr. Blaze has taken the due diligence in order to warn Ms. Azila. In fact, Your Honors, because Mr. Blaze is not in his effective authority and control over the BNS and over the alleged detention centers, then Your Honors, this just shows that Mr. Blaze has taken the necessary preventive mechanisms and extra steps of initiative in order to curb against any possible unwanted possibilities. Madam President, Mr. President, my apologies, Your Honors, we must see that justice and law are trees planted by the court in order to prosper. And consequently, the crucial question here is, are the allegations made by the prosecution bearing any fruit? We assert it does not, and only rooted in one witness account. Your Honors, we assert Mr. Blaze is not of the highest responsibility. If there are no other things that we can help the court with, we respectfully end our rebuttals here. May it please the court.
Thank you. Then, so we go to the deliberation rooms. Please wait for a while.
So everybody will be sent into separate breakout sessions, including the judges.
So maybe you all are present, okay? So first of all, thank you for your patience and for your really strong pleadings. That's why it is quite difficult for judges to make a decision. Nevertheless, we must choose only one team. Then we have now decided that the winner is the Defense Council. And now I will ask my colleagues to give some comments. Maybe first, Mr. Owiso. Could you give a comment, please?
Yeah, sure. Just maybe just one general observation. But first, thank you for this. I mean, this has been an immense pleasure listening to you. You're two very strong teams. I do not think I would have done what you have done during my time. I think the bar is much higher this time around, as opposed to years back when the rest of us chickened out of this. So congratulations. This has been wonderful to listen to, and for those who are proceeding, I wish you well. I will not give specific comments for reasons that some of you are still proceeding, but just one thing to note going forward and for future litigation. When you are referring to authorities, it is important to point to the specific authority you're referring to, because in some of these decisions, it could be one case, but there are several decisions that have been made by several branches, several chambers and whatnot. So just be specific on which one you're referring to. And indeed, as you might have noticed, I am lost for words. I was very impressed by the prosecution. I was very impressed by the defense. So again, congratulations. And I hope you had as interesting experience as I have had as a judge, or probably even better. So that's it for me.
Thank you, Judge Owiso. Then maybe, do you have any comment, Ms. Struyven? Sorry, unmuted. Excuse me. Please unmute it.
Oh, yes.
Thank you.
Here I am. No, thank you very much. I think both teams have been incredibly good. All of the speakers have been very slow, articulated, structured. I really like the fact that you structured it, you announce what you're going to say so that it's much easier for the listener to follow the argument. The only thing I could possibly think of, and of course it's when you do these pleadings, and it's the same when you do them in real life, it's only the rejoinder of the defense where you don't really know what the rebuttal of the prosecution is going to be. And what I've seen today is that, and so you only have 5 minutes or so to prepare, or you have much less time to prepare in advance, let's put it that way. And what I've seen here is that all the speakers were fantastic, really. But what you saw in the rejoinder of the defense, the third speaker, is that you started speaking more naturally. So it was less, let's say, less prepared in a way. And that comes really across really well as well. So basically my message is don't be afraid to sometimes just speak naturally, because it's easier sometimes in pleadings to listen to someone who speaks more naturally. So I really like that part as well. But as you know, in the ICC, most of the times we prepare our pleadings quite well, and we have the notes and we have everything ready. So in any event, I think in short, everyone was really, really well prepared and really delivered quite impressively, I must say. So very well done, and I hope to see you in real proceedings maybe one day. So really well done.
Thank you, Judge Struyven. I will just add one point. So actually, the prosecutor side is also, I found, very good teamwork. Your arguments are very well structured. And most impressive for me that both teams could respond to each other very well. This point, I couldn't find particularly in preliminary rounds. That's why both teams, I think you worked very well. Yeah, thank you very much for your participation and very hard work to this moot court. Yeah, this hearing. So now I will maybe close this hearing. Thank you to all.
Thank you, Your Honors.
Thank you, Your Honors.
Thank you very much, Your
Thank you
Honors.
very much, Your Honors.